Hello students, my name is Udana Soisa. I've done at law. I've been a lecturer with the University of London for nearly a decade now. In this short series, this 5 minutes series, we will learn the basics about various subjects within the University of London syllabus, ranging from contract law, criminology, jurisprudence, criminal law, international law, even to areas such as legal systems, public law, trust and equity, property law, and etc. So I hope that you stick with us and learn to think and analyze through these little videos we are bringing to you. So in this lecture today, we will learn the basics of jurisprudence. So what is jurisprudence? Right? It's a study of law, or it's the science of law, or it's rather the philosophy of law. So you can look at it in different angles. Some see it as a study of law, some see more of it as a philosophical reality, some even see it as a scientific reality which is linked to law. There are two key starting theories you need to understand: the concept of positivism and the concept of natural law. How do they differ? Natural law believes that law exists in nature. There are both secular views and theological views. The theological views believe that, that the law is a creation of God. The secular view believes that law comes or flows from the human consciousness. Again, both the theological view as well as the secular view believes law or legal reality as a natural reality. It is not a creation of man. It is not posited by man. It is rather an existence in Mother Nature. So a key point about all types of natural law theories is that they always and often link morality with law. The content of the law is important. Some of the authors, such as Cicero, historical perspectives of natural law, believes that if the law is unjust, that is not real law. So in terms of natural law, the focus is on the content of law, with a very limited or no focus on procedures. However, the positivist view is very different. Positivist view believes that law is posited. Law doesn't exist in nature, but law rather is a posited reality or a created reality by men. The content of law is not relevant. What positivists believe, if law is made by the correct authority using the correct procedures, it will be valid. So you have hard positivists such as Austin, you have soft positivists such as H.L.A. Hart, you have some pure theorists such as Kelsen, and finally remember the starting point of the positivist ideology with the likes of Hobbes, who speaks about the social contract back nearly 600 years ago. So having discussed natural law and positivism, we can look at some other modern contemporary views about law. Marxists, for example, believes law as a tool of the bourgeois or the ruling class or the haves to oppress the poor. So law is being used by the bourgeois to oppress the proletariat. The law is not neutral. According to Marxist view, law is a tool of oppression. According to the feminist view, for example, law is a tool in which men oppress the women. So there's a gender perspective about law when it comes to feminists. There are many kinds of feminist views, and do not make the mistake to bundle up all feminists as one group. For example, black feminists focus a lot more in terms of minority rights. The liberal feminists focus on equality. Postmodern feminists see the relative aspects of oppression. Lesbian feminism wants to take the discourse more towards lesbianism. And most importantly, the cultural, the ethics of care, or the different feminists, they focus on the differences, the gender difference. Not necessarily about the equal place, but rather about the due place. So, my final author for this jurisprudence lecture is Dworkin, who's in fact an anti-positivist. According to Dworkin, you cannot understand a legal system with rules. According to Dworkin, to understand legal system, you have to understand the concept of principles. Rights, according to Dworkin, trumps all realities. Judge should never make law. Judge has to always interpret law as per Dworkin. So there's an interpretative part in his jurisprudence. Finally, there's always one right answer. According to Dworkin, law may not be a seamless web, but claimant can treat as it is. Thus, one needs to understand there's a very practical, a third type of jurist in Dworkin. So thank you so much for this opportunity to enlighten you. I hope you will take your course about jurisprudence very seriously. At the same time, have fun. Jurisprudence is such a beautiful and interesting area of law. Don't memorize, understand the basics. When you think of natural law, think of morality. When you think of positivism, think of posited legal realities, law being created, separation between law and morality. When you think of feminism, think of gender oppression. When you think of Marxism, think of class oppression. When you think of Dworkin, always think of principles. Right? So that's it for today's lecture. Thank you so much.